If you are in the UK right now without a visa, I want you to stay with me for a few moments. Because one assumption destroys more cases than any refusal letter ever could. And that assumption is, I have got no options. Now, I understand why people think that. When you have no leave, everything feels urgent. Everything feels risky. And most people are frightened to even ask the question. But here is the truth. In many cases, that belief is simply wrong. My name is Sajjad Kayani. I'm a solicitor for almost 20 years. I specialize in immigration, family law, and litigation. Day in, day out, I deal with real people, real families, and real consequences. Children's education being disrupted, partners being separated, enforcement actions, and years of uncertainty hanging over a family. So what I want to do today is talk you through the private life route under the UK immigration rules, updated on 8th of Jan 2026, and explain in plain English how it can help some people who currently have no leave to remain to regularize their stay lawfully in the United Kingdom. Before we go any further, just two quick things. First, this is general information, not legal advice for your specific case. Immigration cases turn on detail, dates, travel history, previous application, and suitability issues. So please do not take this as a substitute for tailored legal advice. And second, please do not post personal documents or fully identifying details in the comments. Keep it safe. Now, if you find this video useful, do me a favor, subscribe to the channel and share it with one person who needs it. Most people suffer in silence because they are scared to ask. And honestly, a single share can be the nudge that gets someone to seek help before it becomes a crisis. Right, let's get into it. The private life route exists because UK law recognizes something very simple. People built their lives here. Children grow up here. Young adults become who they are here. Adults can spend decades here, and their whole identity becomes tied to the United Kingdom. And in certain circumstances, refusing leave or a visa can breach the right to respect for private and a family life. Where children are involved, the Home Office must treat the child's welfare as a primary consideration. So this is not sympathy. This is rules, legal tests, and evidence. Now, the easiest way I can help you understand whether this route might apply to you is by asking you a few very direct questions. And as you listen, I want you to answer them for yourself. So the first question, are you under 18? And have you lived in the United Kingdom continuously for at least 7 years? My second question is, are you aged 18 to 24? Did you arrive the United Kingdom before you were 18? And have you spent at least half of your life living here continuously? The third question gonna be, are you an adult? And have you lived in the United Kingdom continuously for more than 20 years? And then fourth question, which is the one people often misunderstand. If you do not have 20 years, do you face very significant obstacles to integrating back into the country you would have to live in if you are required to leave the United Kingdom? Now, these questions aren't random. They map directly onto the private life rules. And once you know which category you fall into, you stop guessing and you start building a proper case. Let me start with the strongest and most common category: children. So if the applicant is under 18 at the age of the application, the rules require two things. First, the child must have been continuously resident in the United Kingdom for at least 7 years. And second, and this is the key part, the Home Office must be satisfied that it would not be reasonable to expect the child to leave the United Kingdom. Now, that word reasonable is where cases are won or lost. Because it's not just about counting years, it's about the child's actual life. And in practice, the Home Office should be looking at the child's education, health, development, friendship, and the real life impact of the removal. So when we build a strong case, what we are really doing is this: we are putting the child's life on paper in a way that cannot be brushed aside. For example, we show schooling and a progress, attendance records, school reports, teacher letters, special educational needs, sport if there is any, projected grades, examination stages, and then we have to demonstrate health and welfare, GP letters, hospital appointments, counseling, care plans, anything relevant. After that, we show community ties, clubs, faiths, groups, activities, achievements, friendship. Then we have to demonstrate language and integration. What language the child reads and writes in, and what their real connection is to the country of return. And then, importantly, we deal with the reality of relocation. Not the theory, the reality. Where would the child live? What school would they attend? Any healthcare would they receive? Who would support them? And what would that disruption actually do at this stage of the child's life? Now, if you are a parent listening to this, there is often an additional legal angle in play as well in many non-deportation situations where you have a genuine and subsisting parental relationship with a qualifying child, and it would not be reasonable for that child to leave the United Kingdom. The law recognizes that removal of the parent may not be in public interest. That is why children's private life cases must be handled carefully and properly, because they can protect an entire family unit. At Kayani Legal, we treat these cases like litigation. That means we prepare a clean chronology, we gather the right evidence, and we produce legal submissions that make the decision as straightforward as possible. Now, let's move to the next category, which is young adults aged 18 to 24. This one is important because people miss it all the time. Now, you are aged 18 or over and under 25, and you arrived in the United Kingdom before the age of 18, you may qualify if you have spent at least half of your life continuously resident in the United Kingdom. And what I want you to hear here is this: if you fit that profile, do not assume you missed your chance because you are no longer a child. This route exists precisely because someone can grow up here, form their identity here, and develop deep ties that cannot simply be transplanted overnight. But, and there is always a but, it is evidence heavily. You must prove your timeline properly, entry dates, residence year by year, school records, letters, and clean absences history. In other words, you build the story with documents. Now, adults. For adults, there are two main gateways under the private life. One, more than 20 years continuous residence in the United Kingdom. The second one, if you do not have 20 years, you must show there would be very significant obstacle to your integration into the country you would have to live in if required to leave. Now, I want to slow down here because very significant obstacle is one of the most misunderstood phrases in immigration law. This is not, I will struggle. It is not, I don't want to go. And it is not, I have no money. It must be serious, real-world barriers supported by evidence. For example, a person who has no meaningful support network at all, serious medical issues with limited access to treatment, disability or care needs, extreme social isolation, or severe cultural and language barriers combined with very long UK residence. The point is, it must be genuine and it must be evidenced. And this is exactly why copying someone else's application is so dangerous. Because the legal test is strict and the evidence must fit that test. Now, let me mention a technical point that destroys cases, even where the person has a long history in the United Kingdom. Continuous residence, private lives allows the relevant residence period to include time with or without permission. So in many cases, even unlawful residence can count towards the 7-year half-life or 20 years periods. However, and this is crucial, continuity can be broken. So certain long absences can break it. High total absences can break it. Removal or deportation events can break it. And periods of imprisonment do not count. So here is the practical advice. Do not rely on memory. Write it down. Prepare a travel and a residence chronology. Prepare a proper chronology. Put dates in and out. Put every address, put every school or workplace, and then match it to the evidence, passports, whole email, NHS records, HMRC letters, tenancy agreements, school letters, bank statements, like pay slips. This is what turns a vague claim into a strong case. Now, another issue that looks small, but it is actually fatal: validity. Private life applications must be made on the correct online forms. The applicant must be in the UK on the date of application. Biometrics must be provided when required. Identity must be proven. And fee and the immigration health surcharge normally must be paid unless you qualify for a fee waiver. If affordability is your barrier, a fee waiver may be possible in the right cases, but it must be approached properly with evidence. If it is done badly, it can delay everything and keep you stuck in limbo. Now, I promised you two biggest mistakes. So let me give you the 3 I can see again and again. Mistake number 1, filling the wrong route because a friend did it. Private life is not one size fits all. Strategy comes first, then the form. Mistake number 2, deception or false documents. Please hear me clearly. Do not do it. Do not use fake papers. Do not exaggerate. Do not hide refusal. Suitability issues can destroy not only this application, but also future settlement and citizenship plans. Mistake number 3, ignoring the end goal. Private life is described as a route to settlement, but settlement has its own rules. A good solicitor plans from day 1 how you get leave now and how you get settlement later, safely and lawfully. Now, one more important point. Some people should not be applying under private life at all. If you have 10 years of lawful continuous residence, often across different visas, then a long residence route may be the better strategy and can lead to settlement. That route is technical and it depends on the exact dates, absences, and visa history. So it must be checked carefully before you choose your pathway. So, what should you do next? Here is your practical action list. First, identify your category: child 7 years, young adult half-life, adult 20 years are very significant obstacles if you have not completed 20 years. Second, build your timeline: UK entry dates, all addresses, all absences, schools, workplace, and any previous immigration applications or refusals. Third, gather evidence in layers: identity, proof of residence, proof of integration, children's records, and professional evidence where relevant. Fourth, check validity issues before you submit. Correct forms, biometrics, fee or fee waiver strategy and keep everything consistent. And fifth, do not gamble. A refused application can create serious problems, including enforcement risks and washed fee. The right approach is correct route, correct evidence, and correct drafting. If you want us to assess your case properly, Kayani Legal can do a structured eligibility reviews and produce a clear strategy. Which route is best, what evidence you need, how to address weak points, and how to present the case properly. To make that assessment efficient, send us a short message with your UK entry dates, your visa history, if any, if you have your granted status, any refusal, and if you have children, their dates of birth, and how long they have lived in the United Kingdom. And of course, if last but not the least, if this video helped you, subscribe and share it. I'll keep publishing practical UK immigration guidance in plain English so you can take the right step at the right time. And remember this, being without a visa does not automatically mean being without options. It means you need the right route, the right evidence, and the right strategy. See you soon.